law firm of Villasis and Partners, VP Law, is a law office engaged in the general practice of law. Its principal office is conveniently located at the heart of the University Belt at Villasis Law Center, VLC, Unit 911 CKKFI Building P. Paredes Street, Sampala, Manila. VP Law was organized in 2015 by attorney Christian G. Villasis and continues to expand to date. From the start, VP Law has maintained a varied and prestigious client base and continues to be recognized as one of the leading law firms in the country. VP Law has a diversified general law practice as the firm handles all aspects of corporate, commercial and business transactions, protection and enforcement of intellectual property rights and data privacy rights, collection, civil and criminal litigation, admiralty and maritime practice, labor management relations, election, administrative and local government cases, real estate transactions, land titles, deeds and conveyances, foreclosure of mortgages, writ of possession, replevin, bought laws, business organizations and corporate regulatory compliance and taxation, among others. In addition, the firm offers contract drafting, review, and negotiation, legal research and consultation, as well as other legal assistance pertinent thereto. At present, the firm's increasing number of lawyers is capable of handling various legal matters and cases and is able and willing to cater to clients' concerns with utmost professionalism and zeal. Apart from experienced VP Law lawyers, its legal team includes highly competent paralegals and professional legal staff who are constantly inclined to assist the lawyers, thereby ensuring efficient and cost-effective service to its clients. VP Law aims to provide its clients with quality legal representation anchored on the ethics of hard work, commitment and responsiveness to clients' needs. This vision has been the moving force in the firm's growth into a first-rate, full-service law firm.
VLC Warriors, please visit and subscribe to Villasis Law Center YouTube channel. Together, we can make things happen. Together, we can.
course, in cases filed against you, you don't merely avoid conviction. Of course, there are some things that you would also have to consider. First, the time. Second is the investment. Third is the opportunity. Fourth is your peace of mind. And fifth is your personal wealth. So out of the 100 targeted accounts, hackers were able to reset 45 user accounts' passwords. Now, these hackers
be very fast in saying, yes, I want to go fishing with you, because this person might be talking about a different kind of fishing, a fishing that will lead to a criminal offense and probably put you in prison.
Does not fall under the Data Privacy Act if it is an information pertaining to an entity that is not a natural person. Consent must be something that is mechanical and tangible. It must be proven. That is consent that is required under the Data Privacy Act. You have to prove that you have obtained the consent from a data subject. So who may wish to have some questions, probably they can send their questions to the Villasis Law Center and we'll try to answer them.
Three things, no? We were reminded by the National Privacy Commission that the cardinal rule, if you talk about processing of data information, is that do not collect if you cannot protect. The primary impact of the Data Privacy Act, my friends, are the 8 rights provided by law. Very important. There are 8 rights here. You talk about the right to be informed, the right to access, the right to erasure or blocking, the right to object, the right to rectify. You talk about data portability, the right to file a complaint, and of course, the right to damages. Data is more valuable than money, because if someone takes your money, that's all they have, okay? But if you let someone take your data, oh my God, eventually they will take your money too.
So does the DPA only cover personal information per se, or does it also cover information about companies, testing results, and...
Hi sir, good
Hi.
evening. Sir, just a question.
Good day to our dear attendees from different parts of the country. I pray that you're all in great state of health. This free webinar is streaming live via the Villasis Law Center's YouTube channel and Facebook page. If you can hear my voice clearly, please type in the comment section hashtag VLC. Thank you. Yes, thank you. Optimize this learning opportunity. Share this free online lecture to your friends and together learn at the comfort of your homes. I want to formally welcome you all to this free webinar. This is part of a series of free online lectures brought to you by the Virtual Law Companion of Villasis Law Center. Allow me to share to you this good news. The Virtual Law Companion is the newest innovation of Villasis Law Center, which aims to provide an easy, convenient, and quality bar review experience. The Virtual Law Companion is a web application that is hosted on a dedicated cloud server. It can be accessed via the internet 24/7 for any web browser, using any device or handheld computers like Android or iOS phones. Meaning, you can study anytime, anywhere, and from any mobile device. Please visit our website at www.villasislawcenter.com to know more about our programs and activities. Before we formally start, please take note of some reminders. First, this free webinar is pre-recorded to ensure the uninterrupted streaming of lectures. Secondly, VLC team will be with you to assist you should you need more information about our program. Please visit and subscribe to our YouTube channel and Facebook page. Without further ado, please give your virtual claps and welcome our lecturer today. Again, this free webinar is brought to you by our Virtual Law Companion. Maraming salamat po. Together, we can make things happen. Together, we can.
Our lecturer finished philosophy at the San Pablo Seminary in Baguio City. He finished Bachelor of Laws at the University of the Cordilleras, formerly Baguio College's foundation. He is enrolled in the Masters of Law program at the San Beda University Graduate School of Law. He is a former president of Veritas Research and Development Institute, and a former consultant to Japan Bank for International Cooperation or JBIC. He is a law professor and bar reviewer in labor law in various law schools and bar reviewer at several bar review centers, including Villasis Law Center. Our lecturer is also an author of books namely, Survival Notes in Labor Law, Bar Syllabus-Based Reviewer in Labor Law, Questions and Answers in Labor Law, Labor Standards Law, a Remunerative and Protective Law, and Labor Relations Law, a Tenurial and Organizational Law. He is a member of the UP Law Center panel of experts in labor law. Currently, he is a labor arbiter at the National Labor Relations Commission. Without further ado, please welcome Professor Benedict G. Cutto.
Pleasant hour. Let me thank Dean Villasis, first of all, for inviting me over to be a part of his lecture series. Our topic is tenurial and remunerative issues in a pandemic setting, law and remedies. Why this topic? Because the pandemic has drastically changed the environment of some laws and even of controlling case authorities or jurisprudence. For those taking the bar examinations, of course, you understand that the current events do influence bar questions. So we're expecting a question or two having to do with the effects of the pandemic. Like for example, in retrenchment, how are substantial loss is supposed to be established? The answer is there is a prescribed form of evidence for doing that. The prescribed form of evidence is financial statements duly certified by an independent external auditor. In the case of Linton Commercial versus Aguilera et al., the Supreme Court rejected the company's evidence of business losses. Why? Because the evidence was not in prescribed form. It was not in the form of audited financial statements, not in the form of financial statements duly certified by an independent external auditor. But on top of that, the Supreme Court noted that the alleged losses amounted to 3M only as compared to the corporate capital of 1B. And the reason was the alleged losses were incurred in just 1 year of operation. So here is the sheet. In a pandemic setting, business losses are claimed based on operations for just a few months. No? Losses are allegedly incurred from just 5 or 6 months of business run. Now, applying strictly settled rulings, controlling case authority, employers will now find themselves in a very difficult situation. They will not be able to prove their losses, okay, in accordance with jurisprudence. In Linton versus Commercial, the Supreme Court said the alleged losses incurred in just 1 year of business run were not reflective of the true financial status of the company. So, if we strictly apply Linton and similar other rulings, then employers would be hard up. Now, of course, we know that the labor law does not only favor workers. The favoritism of labor law for the working man is a tempered preference. While it is true that employer-employee relationship is an asymmetrical relationship in the words of Justice Yunen, explaining the preferential option of labor law for the working man, the law does not, of course, permit the destruction of the employer or his oppression. According to Justice Yunen in Milan versus NLRC of 2015, employers and employees are socio-economic partners, so that in the event of conflicts, disputes between them, the law does not permit the dispute to be the source of or to be productive of the destruction of one at the hands of the other. The new civil code in 1701 does not permit the parties to act oppressively against one another. In the bar, abilities are tested. Of course, abilities can be classified into lower order thinking skills and higher order thinking skills. Lower order thinking skills are abilities having to do with the knowledge and understanding. So, objective type questions are asked to test ability to recall, ability to name, ability to enumerate. These abilities belong to the lower order thinking skills. The other group is the higher order thinking skills, to which belong ability to compare, ability to analyze, ability to synthesize, to judge, to create, to invent. And it is here where we are expecting a question or two. In light of the pandemic setting that has affected the case law and even statutory law, you might be asked to about remedies to take in protecting the interests of your client, who may be an employer or an employee. The purpose of this lecture is to look for new remedies, not new laws, to address issues in a pandemic setting. So the title of our topic is Tenurial and Remunerative Issues in a Pandemic Setting. So what is a tenurial issue? Well, the background is right to security of tenure, which is an employee's right to remain employed until dismissed or adjust or authorized loss. When this right is violated, it generates a tenurial issue. When this issue is raised, more often than not, it comes with the accompanying issue of due process. Because aside from questioning the sufficiency of the employer's ground for dismissal, the employee also raises issues on the employer's compliance with due process or prescribed pre-termination procedure. Now, at this point, please understand that the due process strictly applies to dismissals under 297 or to dismissals based on fault or culpability. The law guarantees to the employee sought to be dismissed the right to be heard, okay, that he may come to the protection of his employment. Now, due process as right to be heard does not apply, strictly speaking, to dismissals for authorized causes under 298 because in such dismissals, the employee has nothing to explain. In fact, it is really the employer who has something to explain. It is the employer who needs to be heard on the basis of his termination, decision to terminate based on retrenchment, redundancy, etc. So, the proper term to apply for dismissals under 298 for authorized causes is prescribed pre-termination procedure. Now, in a pandemic setting, barring bad faith, barring pure refusal to pay, an employer's inability to pay, earn salaries, and accrue benefits may already be a sign that it is in the black, worse that it is in the red. An employer who is in the red, who is financially bleeding already, is allowed to adopt extreme measures to survive. These extreme measures include retrenchment, redundancy or preventive retrenchment. The other name for redundancy is preventive retrenchment. To include flexible work schedules like compressed work week. Now, so remunerative issues are money issues. So these issues, tenurial and remunerative, usually come together. Now, so how far has COVID-19 affected our laws? Relative to flexible work schedules, Linton Commercial versus Riviera tells us that the adoption of a flexible work schedule requires compliance with three preconditions or prerequisites. Number one is necessity. Number two is voluntariness. Number three is temporariness. Necessity, law-wise, jurisprudence-wise, is understood as financial difficulty on the part of the company. Now, that has been affected by the pandemic. Why? Because employers who need to go into flexible work schedules may not really be in financial difficulty, but because of health issues, health concerns, they need to adopt certain measures to address the situation. So the requirement that necessity be economic based may have already been affected. Number two, voluntariness. Now, the Supreme Court requires that the affected workers should be consulted first and that their consent be secured first. Now, in a pandemic setting, what would be the extent of that right to be consulted? Can they say, no, we have to go to work because we want to go to work, we want to earn? But the employer says, you cannot, no, you cannot. So, this second condition has been affected also. Then, temporariness, which is 6 months, has been affected also. Because the 6-month period may be exceeded by the COVID situation. So, these are some of our concerns. We have to look into new laws apply, if any, and new remedies to make use of, if there are such a remedy. So we shall be in search of laws to apply and the remedies to apply. Take note that the Party Chair, Justice Junet, has told us in a 2015 case about the social utility theory. Okay, under this theory, as I said a while back, parties to employer-employee relationship are treated, they are considered as socio-economic partners. So that in the resolution of their disputes, the courts are under instruction to always look for middle grounds. Why? Because the rights of the parties to EER enjoy equal protection under the law. So we shall be in search of such middle grounds if there are any. The instruction of the court in Milan is not to invent, is not to devise such middle grounds, but to find, which implies that there are pre-existing middle grounds. Okay? We are not supposed to create or to devise middle grounds. Why? Because if we do that, then that would not serve the interest of industrial peace. Because the relief given today, based on an invented middle ground, may be easily withdrawn tomorrow, on appeal, for example. So that would not be in the best interest of industrial peace. So the question we shall tackle throughout this session is whether or not there are pre-existing middle grounds. We shall be in search of them. So more or less, that is the target of this session. I don't usually smile when I lecture, because when I do, I look like Pastor Kibuloy. Okay. Possible question in the bar. Distinguish in the red from in the black. I mentioned this a while ago. A company that is in the red is allowed to adopt extreme measures like retrenchment, like compressed work week. In the case of a Linton commercial company, Incorporated versus Ilyara et al., involves compressed work week. On the day the company adopted compressed work week, it implemented it. What is the difference between a compressed work week and reduced work days? In a compressed work week scheme, the work week, which consists of 48 work hours, can be reduced to, say, 4 days. And when that is done, the 48 hours will be divided by 4 days. That will give you 12 hours. The 12 hours will now become the new normal hours of work. So no overtime pay for work rendered between the 8-hour and the 12-hour, because the 12 hours have now become the new normal hours of work. So you will take note that in a compressed work week, there is no reduction in both work and pay. Why? Because the 48 hours will remain at 48 hours. So compressed work week does not involve reduction in work and pay. In contrast, reduced work days involves reduction of work and pay. Because in reduced work day situation or arrangement, the 6 days, assuming that is a normal number of days work in a week, can be reduced to 4, and when that happens, the 48 will be reduced to 32 only. Why? Because the 8 per day will remain at 8. So 8 times 4 equals 32. So what do you notice? The reduction of work from 48 hours to 32 hours. So because of the reduction in work, there is also reduction in pay. So because the arrangement results in economic loss on the part of the employee, there is a cap of 6 months for reduced work days. That cap, so far as Advisory 2, Series of 2009 is concerned, does not apply to compressed work week. Okay? So it strictly applies to reduced work days. Again, the reason is in reduced work days, there is economic deprivation or loss on the part of the affected workers. But here is jurisprudence that also puts a cap of 6 months now, even for or on compressed work week. Now, what happened in Lincoln? On the day the company adopted compressed work week, it implemented it. Whereas it was supposed to be compressed work week, there was reduction of both work and pay. The reason the workers questioned the validity of that work schedule. And the Supreme Court agreed with the workers that the compressed work week was not valid for the following reasons. Why did the company resort to compressed work week? According to the company, because it sustained or it incurred losses of how much? 3M. But that was rejected by the Supreme Court because to the mind of the Supreme Court, those were not substantial losses. Because compared to the corporate capital of 1B, 3M losses would not amount to substantial losses. Number two, the alleged losses of 3M were not supported with financial statements duly certified by an independent external auditor. Number three, the losses were incurred in just 1 year of operations. And number four, the company was still earning income sufficient to cover or fund its payroll. So it was not yet in the red. It was only in the black. So the difference between in the red, these are financial conditions, positions, situations, and in the black is that in the red means that the company is financially bleeding already. It is suffering from economic hemorrhage. Whereas if it is only in the black, because it is still earning income sufficient to fund its payroll, no, then it is not allowed to adopt extreme measures, including compressed work week. So please be ready for this question, in the red versus in the black. Okay. Now back to compressed work week. We said that the preconditions are number one, necessity, number two, voluntariness, and number three, temporariness. The Supreme Court could not see the first requisite. In other words, there was no necessity for adopting compressed work week. Why? Because the company was not yet in the red. It was only in the black. Number two, take note that on the day the company adopted compressed work week, it implemented it. What does it mean? Okay, it means that the concerned workers were not consulted and that their consent was not procured first. Number three, we said a while ago that under Advisory 2 Series 2009, there is no cap for compressed work week. But here is the third reason why the Supreme Court nullified or rejected the company's compressed work week. Okay, it exceeded 6 months. Okay, so based on jurisprudence, there is now a cap of 6 months even for compressed work week. So this is your Lincoln Commercial Company. It has not been given in the variant. So be ready for this one. Again, because the question on compressed work week may be prompted by COVID-19. Burden of proof. In the foreclosure of tenure, or the right to security of tenure, the rule to observe is it is the obligation of the employer to justify the dismissal. And in the language of the Supreme Court in Duty Free Philippines versus Tria, 2012, now Chief Justice Pararda, proof of the validity of a dismissal must be upon clear and convincing evidence. Clear and convincing evidence. So this brings us to burden of proof, where topmost is proof beyond reasonable doubt. Number two is not preponderance of evidence, but clear and convincing evidence. Number three is preponderance, and number four is substantial evidence. When in Duty Free Philippines versus Tria, the Supreme Court told us that the employer has the burden of proving the validity of dismissal with clear and convincing evidence. Did the Supreme Court tell us that burden number four has become burden number two? In other words, has the Tria Court elevated substantial evidence to clear and convincing evidence? That seems to be the import of the decision of the Supreme Court. But let's look at the development of jurisprudence in this area. In the case of Manalo versus Confessor, the Supreme Court told us that the employer or the burden of proof in administrative cases, including labor cases, is substantial evidence only, defined as such relevant evidence which a reasonable mind might accept as adequate to support a conclusion. The Supreme Court in that case told us also that the burden does not change. So it will always be substantial evidence. About 10 years later, in the case of SMC versus NLRC, the Supreme Court said the employer must prove the validity of dismissal clearly and convincingly with substantial evidence. Clearly and convincingly with substantial evidence. And here comes Duty Free Philippines, which tells us that the employer must prove the validity of the dismissal with clear and convincing evidence. So we are looking at what appear to be conflicting rulings of the Supreme Court, but we have to ask if the conflict is real or simply apparent. This seems to be conflicting. They also seem to be conflicted because in SMC versus NLRC, the Supreme Court said the employer must prove the validity of the dismissal clearly and convincingly. So it looks like with burden number 2, but with substantial evidence. How to harmonize all these rulings, we have to go to the ruling of the Supreme Court in Masing and Sons, where Justice Bersamin gave us the 2 types of substantial evidence. In Masing and Sons, the Supreme Court said that the employer must prove the validity of the dismissal, observing qualitative substantial evidence and quantitative substantial evidence. So, while the burden of proof is the same for both employer and employee, because it is always substantial evidence, the employer is required to do more. Before we proceed, that burden will not be imposed on the employer unless the employee has first discharged his burden of proving the fact of his dismissal. And how does an employee discharge his own burden of proving the fact of his dismissal? Well, he has to prove 1, 2, 3, 4. Number 1, prove employer-employee relationship, unless, of course, admitted. Number 2, prove the complete destruction or severance of that relationship, unless admitted also. And number 3, prove the employer's overt act of dismissal. Now, take note of 2 important tests here. Number 1 is the complete severance test, and number 2 is the overt act test. Why is there a need for these tests? Well, in relative to number 1, the complete severance test, there are instances where there may be cessation of work, and yet there is no dismissal to speak of. Why? Because the cessation of work is temporary only. There is no complete destruction of the legal tie between the employer and the employee. These circumstances include the 4 instances or circumstances under Article 301 of the Renumbered Labor Code. They are the following: temporary suspension of business operations by reason of repair of machineries. Number 2, temporary suspension of business operations by reason of conduct by the employer of an inventory, rendition of military duty, rendition of civic duty. Outside 301, there are other instances where there is no dismissal to speak of because there is no complete severance of employer-employee relationship. What are these additional instances? Preventive suspension. A preventive suspension is not productive of complete destruction. That's why in the case of Joe Cinema, the Supreme Court held that there was no dismissal to challenge by complaint before the labor arbiter. Why? Because the complaining employee filed a complaint for illegal dismissal with the labor arbiter, okay, after being placed on preventive suspension for having violated, for having disobeyed her instruction not to encash personal checks with her cash collections at the movie house. While awaiting her explanation, because she was directed to submit explanation why she should not be subjected to disciplinary action by her company, she ran to the office of the labor arbiter to file that complaint. Supreme Court said, okay, you were just placed under preventive suspension, you have not been dismissed. Lesson from this case is where there is no complete destruction of employer-employee relationship, there is no dismissal to speak of. There are additional instances, okay, where we cannot speak of a dismissal because the relationship is still intact, okay? Lockdown, for example, okay? Employees on leave without pay, okay, in the construction industry. So these are additional instances that call for the application of the complete severance test. What about the second test, the overt act test? Why is there a need for us to observe, apply this test? Because in like manner, there are instances where employer-employee relationship may have pre-existed, where that relationship may have been completely severed or destroyed already, and yet the employer cannot be held liable for illegal dismissal. Why? Because he has not committed an overt act of dismissal. If you ask why there was complete destruction or severance of employer-employee relationship, the answer is because of law. Okay. What law? Retirement law. So it is law that terminates employer-employee relationship. Number two, resignation. Okay. Abandonment. Completion of project and expiration of contract. Because of these circumstances, we have to apply the overt act test. Find out what really terminated the employment of the complaining worker. If it is law, contract, project, expiration, etc., then you cannot hold the employer liable for illegal dismissal. So the rule is once the after the employee has discharged his burden of proving the fact of his dismissal, the burden now can be imposed on his employer to justify his dismissal. That is to move forward with evidence to prove his just or authorized source. To prove his just or authorized source. Now, we will go back to the next slide, okay, to the two types of substantial evidence, okay, to show that while the burden of evidence is the same for both employer and employee, the employer is required to do more. Okay? There is a prescribed form of evidence for proving this fact. Okay? In contrast, the employee is not required to observe any prescribed form of evidence. So that will be tackled in the next slide. Now, take note that when an employer dismisses under 298, in other words, for an authorized cause, he has qualitative substantial evidence to present, or he is required to present qualitative substantial evidence. What if the ground relied upon by him was retrenchment? The qualitative substantial evidence he has to present, okay, is the evidence of his substantial losses in the form of financial statements duly certified by an independent external auditor. So those statements, audited statements, form what you call qualitative substantial evidence. Let us change the situation. What if the ground relied upon by the employer was redundancy? There is also a prescribed form of evidence. Now take note that qualitative substantial evidence has something to do with form of evidence, with relevance, with admissibility. So if the ground was redundancy, then there is qualitative substantial evidence to present. There is prescribed form of evidence to present, and that evidence is a feasibility study, okay, approved by higher management, showing that the reduced manpower can still meet the same business target. Because if the reduced manpower cannot meet the employer's business target, okay, then there is no justification for the streamlining, for the reduction of the manpower. So that is also qualitative substantial evidence. Let us change the situation. What if the ground relied upon was a ground under 297? In other words, the dismissal sought to be justified or required to be justified is a dismissal for a just cause based on the employee's fault or culpability. Okay? Then the employer has quantitative substantial evidence to present to justify the dismissal. Take note that quantitative substantial evidence has something to do with number, okay, with requisites, with elements, with preconditions. So, if the ground, for example, relied upon under 297 is willful disobedience, then the employer must prove 1, 2, 3, 4. Okay, so these are the prerequisites of willful disobedience. So, number one is prove the existence of a reasonable rule. Okay. Number two is prove that that rule pertains to the work performed by the dismissed employee. Prove that the employee had been pre-notified of that rule. Prove his willful disobedience of that rule. And number five, prove, okay, that his willful disobedience is attended by wrongful and perverse mental attitude. So what do you see? 1, 2, 3, 4, 5. You see number, you see quantitative substantial evidence. So again, while the burden of proof is the same for both employer and employee, because it is substantial evidence, the employer is required to do more because under certain circumstances, he is required to move forward with qualitative substantial evidence. It depends on the ground relied upon by him. At other instances, he is required to move forward with quantitative substantial evidence. So, it depends on the just cause relied upon by him. Okay, he has to prove the requisites of the just cause. So, you might be asked to distinguish qualitative substantial evidence and quantitative substantial evidence. So, again, qualitative substantial evidence has something to do with form of evidence, whereas quantitative substantial evidence has something to do with number, quantity. Okay? Now, what about the employee? Okay, is he required to move forward with either qualitative or quantitative substantial evidence? Take note that, once again, how does he prove the fact of his dismissal? Number one is prove employer-employee relationship. Number two, complete destruction. And number four, the employee's overt act of dismissal. Take note of number one, proof of employer-employee relationship. It is settled rule that there is no prescribed form of evidence for establishing employer-employee relationship. That relationship can be established with any relevant evidence, okay, like a company ID. In regard company ID, with respect to company ID, in the case of Tape, the producer of Eat Bulaga, the Supreme Court told us that a company ID is not just a means of gaining access to into the premises of the employer. It is evidence of employer-employee relationship. There is another ruling in the glaucoma case, but employer-employee relationship can be established with any relevant evidence. So this is your Masing and Sons Development Corps versus Rogelio. This case gives us at least these two types of substantial evidence. Okay, don't forget, pandemic setting tayo. The bar examiner will dismiss 300 workers due to financial losses. And then he will ask you to give him or to tell him what course of action you would take to protect the interests of those 300 dismissed or employees subject of retrenchment notices or notices of redundancy. So, back to financial losses. How do we determine the financial status of an employer? Well, basically, we have to consider two basic facts. namely income and expenses. Income and expenses. When income is higher than the company's expenses, it can be said that the company is in good financial state, except if its source of cash is the sale of fixed assets, in which case it cannot be considered to be in good financial state, because to be in such a state, its cash must come from regular and permanent sources. So sale of fixed assets, a source of cash, will not reflect healthy financial status so far as that company is concerned. Now, if expenses are higher than income, then the company is in bad financial shape. Okay. Now, I'm not competent in this area. I just did a little reading so I can present you something like this to understand financial status. There are two bases for making an accounting, the cash basis and the accrual basis. In cash basis, income is reported when received. On the other hand, expenses are reported when paid. So income is reported when received, money is received, no? Expenses are reported when paid, so money is paid. In contrast, in accrual basis, income is reported when earned. Take note that earned does not necessarily mean received. No? So collectible is income under the accrual basis. On the other hand, expenses are reported when incurred, and incurred does not mean paid. Now, what happens if the employer is dishonest? Okay? He submits financial statements based on mixed, okay, cash basis and accrual basis. Why or how? The income reported or reflected in those statements are based on cash basis. No? However, the expenses are reported, stated there, based on accrual basis. So that kind of financial statement cannot be relied upon. It is not reflective of the true financial condition of the company. So labor tribunals who are in receipt of financial statements, okay, even if they may be audited financial statements, should not take those statements hook, line, and sinker. They must do an honest to goodness financial statements analysis. Now, what is the importance of financial statements analysis? No? Financial statement analysis is one on which lenders depend, on which the public depend when investing. Okay. Now, don't expect a labor arbiter, voluntary arbitrator to be an expert in this area. Okay, so it is now the obligation of the counsel for the employees to point out to the labor tribunal the defects in the evidence or the lack of credibility of the evidence. So this is the background from which we are coming. Okay, we will see the remedies that are available to workers in disputing the company's or the employer's evidence of financial losses. Remember that we are moving to or towards middle grounds. Don't forget that that is our objective. We are moving into middle grounds. A while back, we said that if we strictly apply settled rulings, okay, then employers may find themselves in a very difficult situation of not being able to prove their losses. Why? Because if strictly applied jurisprudence would bar their evidence. Eh? Why? Because their losses have been incurred in just a matter of months of business operations. Okay? But then, your chairman gave us a theory, the social utility theory, under which he characterizes employers and employees as socio-economic partners, okay, who are not allowed to act oppressively against one another. Okay? The instruction is for courts to always look for middle grounds for the equal protection of the rights of the parties to employer-employee relationship. So we are close to reaching that point, okay, where we will be seeing middle grounds. Again, middle grounds have to be pre-existing middle grounds. We cannot invent them, we cannot devise them. Otherwise, okay, the relief given today can be easily taken back tomorrow. Why? Because it is not on safe grounds. It is not on safe grounds. This has not been asked in the bar yet. Characterize employer-employee relationship. Okay? So it is a question of fact, it is a question of law, it is a contractual relationship, it is impressed with public interest. Don't forget that it is an asymmetrical relationship. Okay? This is a characteristic which Justice Yunen would want to see, no, in your papers. As an asymmetrical relationship, employer-employee relationship is the affair between non-equals, with the employer being recognized as the strong party and the employee as the weak party. And this is the entire reason for the preferential option of labor law for the working man, who is the weak party. Okay? But while this may be true, okay, the rule to apply, to observe is social justice authorizes neither oppression nor self-destruction of employers. In 2003, this was the bar question. May social justice as a guiding principle in labor law be so used even if it collides with the Equal Protection Clause? May social justice as a guiding principle in labor law be so used even if it collides with the Equal Protection Clause? The suggested answer back then was yes. Okay? And the basis of that suggested answer was this postulate in labor law. Okay? Namely, the basis of labor law is police power. Its purpose is social justice. It was taken to mean that police power can override or could override the guarantee or guarantees of the Equal Protection Clause in the name or at the service of social justice. We have distanced from that thinking, from that postulate, because under the regime of the social utility theory, we always apply, or we have to apply the justice for the deserving rule. Another rule to apply at the service of the social utility theory is the anti-rascal rule. What is the justice for the deserving rule? In one case, the labor arbiter decided the case before him in favor of the complaining worker simply because, to his mind, okay, the complainant was the disadvantaged party and therefore he deserved the protection of his office. And nothing else more. In other words, he did not consider the evidence before him, nor did he consider applicable law. Kasi sabi niya, big party, no, disadvantaged party, I will resolve this case in his favor. Up before the Supreme Court said, the Supreme Court chastised the labor arbiter. The Supreme Court said, it cannot be supposed that every labor case shall be resolved in favor of the working man simply because he is a disadvantaged party. The rule to apply is that every labor case must be resolved based on the established facts and applicable law and doctrine. That is the justice for the deserving rule. The other rule, the anti-rascal rule, no? We saw this in the case of PLDT, wherein the Supreme Court told us that compassion for the poor is an imperative of every humane society, but only if the recipient is not a rascal claiming an undeserved privilege. I'm holding the mic now because there are dogs outside this building and there are roosters. So that you will not be disturbed by their sounds, I have to hold the microphone close to me. Okay, so those are the two important rules that serve the ends of the social utility theory. Again, this theory characterizes or regards employers and employees as socio-economic partners. So they are in an interdependent relationship. Okay, so no canceling out, according to 1701 of the new Civil Code, which gives us the non-oppression principle or rule. So here is the instruction of Milan et al. Versus NLRC 2015. Okay, decision of Justice Leonen. Both labor and employer have social utility, and the law is not so biased that it does not find a middle ground to give each his due. So, middle grounds, okay, must be pre-existing grounds. There are pre-existing middle grounds, and our task is to look for them. They are just there somewhere, okay, for the rediscovering, and not for the inventing, not for the devising. Forgive me for my COVID outfit and the mic, because I can't find the noise cancellation of my OBS. At any rate, here is our first middle ground, judicial notice. Okay. Judicial notice, okay, can be utilized as a middle ground. So this is a pre-existing middle ground because it is in Rule 129 of the Rules of Court. So pre-existing remedy. Take note of the three sections of 129 of the Rules of Court. Section 1, which covers matters subject to mandatory judicial notice. Section 2, which covers matters subject to discretionary judicial notice. And Section 3, which covers any matter which can be taken judicial notice of, motu proprio or on motion, subject to hearing. This we can connect to the rules of procedure of the NLRC, more specifically to Section 2 of Rule 5 of the 2011 Rules of Procedure of the NLRC as amended, which allows the Commission to apply provisions of the Rules of Court by analogy or in a subsidiary manner. Anyway, here is the case of FASAP versus PAL. FASAP stands for Flight Attendants and Stewards Association of the Philippines. This was the dead case resurrected by the four letters of Justice Estelito Mendoza. Take note that your bar chair, Justice Leonen, was one of the two justices who dissented. According to him, the case was dead, yet the Supreme Court resurrected it. Whether or not he will give you a problem based on FASAP versus PAL, I'm not sure. Okay, he might, but he might not. If he wants to be heard all over again, then he might give you a problem based on this case. But if he wants this case, he wants to place his case behind his back forever, then perhaps he will not give you a problem. Anyway, from this case, take note of the following lessons. Linton says, financial losses must be established with audited financial statements. In contrast, FASAP versus PAL says no need for audited financial statements because the severe losses of a company can be taken judicial notice of. But it's not as simple as it sounds. Take note that there were attending circumstances that led the Supreme Court to come to that ruling. The other is harmless error rule. Okay. When error is committed, allegedly the Supreme Court committed several errors, but that error does not affect the validity of the decision, then the error should be disregarded. Number 3, in the determination of retention policy, the workers cannot demand participation. That is not covered by the principle of participation unless the CBA provides that workers should be involved in the determination of retention policy. So those are the 3 important lessons to get from this case. So here is the judicial journey of this case. The case originated from the labor arbiter. In 1998, PAL dismissed members of FASAP by retrenchment, who then filed a complaint for illegal dismissal with the Office of the Labor Arbiter. The Labor Arbiter resolved the case in favor of FASAP for the reason that PAL did not submit audited financial statements to prove its losses, prompting PAL to appeal the decision of the LA to the NLRC. NLRC reversed the LA, so that was the first win for PAL. MR of FASAP denied, so it went up to the Court of Appeals via Rule 65. And for the second time before the Court of Appeals, PAL won, prompting FASAP to go up to the Supreme Court via Rule 45. FASAP versus PAL went to to the Special Third Division. The case was referred to Justice Inares Santiago, who resolved the case against PAL. So that was the second win for PASAP. PASAP won before the labor arbiter and before the Special Third Division. PAL filed MR denied by the Special Third Division. By then, Justice Inares Santiago had retired, and owing to her retirement, the case moved from the Special Third Division to the regular Third Division. That movement was questioned because according to the internal rules of the Supreme Court, when a position is vacated by retirement, death, whatever, that vacant position should be filled up with a member coming from another division. That wasn't followed. So the case was brought to the Special Third Division, where PAL filed a motion for leave to file a second MR. The motion for leave was granted by Justice Corona, but following his granting of that motion, he inhibited because of his prior involvement in the mediation between PAL and PASAP while he was still connected with Malacanang. So, owing to his inhibition, the case was transferred to Justice Velasco, who also inhibited for personal reasons. So, ultimately, the case went to Justice Rion. At that point, more justices of the Supreme Court had retired. Justice Achuta retired, Justice Morales retired, Justice Chico Nazario retired. So, owing to this retirement, Justice Corona, who then became Chief Justice, reorganized the Supreme Court. So he sent Justice Rion to the Second Division. PASAP versus PAL was carried from the regular Third Division to the Second Division by Justice Rion. And that was in accordance with the internal rules of the Supreme Court, which provided that the case must follow its ponente. So what was before Justice Rion? The second MR of PAL, which he denied. At that point, before his denial resolution could reach PAL, Attorney Estelito Mendoza wrote the Clerk of Court of the Supreme Court asking for data. Okay. Number one, who are the members of the division? Number two, who was the ponente? Number three, how did they decide PASAP versus PAL? The Clerk of Court of the Supreme Court elevated those letters to the Chief Justice, Chief Justice Corona, who told Justice Rion that his resolution denying the second MR should be recalled because those letters were giving problems for the Supreme Court. So the case was elevated from the Second Division to the Supreme Court en banc, and that was questioned. Why? Because according to Justice Sereno, there was no 3/5 voting. A case, according to the internal rules of the Supreme Court, would be elevated from a division to the en banc only upon 3/5 voting. So that wasn't followed, according to Justice Sereno, which would be explained later on by the majority by saying that members in the Second Division went up to the Chief Justice to ask him that the case be decided by the court en banc. Okay. Another issue was when the resolution of Justice Rion was recalled by the Supreme Court, Justice Corona took part. That was questioned because of his earlier inhibition, but then majority would say later on that he could rejoin the court in resolving the recall resolution because after all, he was not recalling by himself. That the resolution was a resolution of the court as a collegial court. Now, what is the more or less the judicial journey of PASAP versus PAL? According to Justice Leonen, a dead case was resurrected. Is that important? I don't know. Okay. PASAP versus PAL is an en banc decision. And here is the opening sentence of the decision. Care of Justice Bersamin, now Chief Justice, who later became Chief Justice. By the way, Justice Bersamin and Justice Peralta were members of the Special Third Division. So the Supreme Court said, since you were members of that division, we better raffle the case to one of you. So that's how the case went to Justice Bersamin. He said, in determining the validity of a retrenchment, judicial notice may be taken of the financial losses incurred by an employer undergoing corporate rehabilitation. In such a case, the presentation of audited financial statements may not be necessary to establish that the employer is suffering from severe financial losses. Linton says there is a need for audited financial statements. FASAP says no need. And the reason for that was the NLRC recognized the severe business losses of PAL. The CA recognized the severe financial losses of PAL. Not only that, even the SEC made the same recognition. It was only the labor arbiter who refused to accept the evidence of losses presented by PAL. So all the SEC, okay, the NLRC, the CA recognized those losses. So on the basis of such findings, factual findings, the Supreme Court could take judicial notice of PAL's financial losses. Now, this is a question, okay, that we have to ask. Did the FASAP court do away with the Linden requirement that the business losses be incurred from several years of operation? Looks like the case is silent on this one, okay? Does FASAP apply only when there is a corporate rehabilitation? Honestly, I do not have answers to these questions. Just take note that FASAP versus PAL is an en banc decision. So in accordance with the Section 4, Article 8 of the Constitution, okay, Linden may have been abandoned to some extent by this en banc resolution, but not entirely. Focus on the one, what the Linden court said regarding losses incurred in just 1 year of operation. I don't think that has been greatly affected by FASAP versus PAL. So we must still search for a middle ground. Okay, so we have to see to it that the rights of the parties will receive the protection that they deserve. Remember your higher order thinking skills. The bar examiner might give you a problem that calls for remedies. No? He might give you a problem that you have never read about before. And this happened several years back when the examiner gave this problem. The company served retrenchment notices to several of his employees. And the question was, what course of action would you take to protect the interests of your clients, of those workers? Would you have gone to the NLRC or to the regional director to ask the regional director to stop the intended retrenchment? Answer is no. Why? Because the regional director did not have that power. He does not still have that power. Would you have gone to the RTC to get a TRO to stop the intended retrenchment? Answer, for lack of jurisdiction, we would not have done that. Would you have run to the NLRC to get a TRO or a writ of injunction? The answer, no. Why? Because injunction is an ancillary remedy which requires a principal case. So remember that the matter is still before the regional director. Okay, so no principal case yet until a case or a complaint for illegal dismissal is filed with the Office of the Labor Arbiter. So we got that from the case of PAL, where the Supreme Court said you should file a complaint for the illegal dismissal first in order to have a principal case. Thereafter, you can invoke already the ancillary or the injunctive power of the NLRC. Now, your problem in the bar would be this. Your client, the employer, has no financial statements, has no audited financial statements. The middle ground here is, so again, FASAP versus PAL may not be totally sufficient to give protection to your client. The middle ground here is preventive retrenchment. Don't forget this other kind of retrenchment. The other kind is retrenchment based on actual losses. This type is based on expected losses. So you don't have financial statements, or even if you do, those statements cover several months of business operations only. So under Linton, okay, you will have a problem with your evidence. But then, if your purpose is to prove a trend of losses, you can still present evidence of losses from several months only of business run, okay, to prove a trend of losses which, if not averted, would result in the company's collapse. So for that reason, your client is still allowed to retrench, but this time based on expected losses. But we have to, of course, make use of certain rules to support your course of action. The rules of procedure of the NLRC 2011 as amended, okay, has three important provisions. Okay. Rule 5 instructs the labor arbiter to make use of all or of any and all means to ascertain the facts of the case before him. Likewise, Rule 7 instructs the NLRC to do the same. Okay. Make use of any means, any and all means to ascertain the true facts of the case. Now, how do regular courts admit evidence? Okay. In addition to evidence presented by the parties, the Supreme Court or the courts can take judicial notice of matters. So here is 129 that allows that. Section 1 of 129 gives us the list of matters which are subject to compulsory judicial notice. So like the official acts of the different branches of the government, world constitutions. Section 2 gives us or covers matters subject to discretionary judicial notice, like those of public knowledge, those of unquestionable demonstration, and those which courts ought to know by reason of their discharge of their judicial functions. Section 3 covers any matter, okay, which can be taken judicial notice of on motion or motu proprio. If by motion, the motion is subject to hearing. So you connect this to the Section 3, Rule 1 of the 2011 Rules of Procedure of the NLRC, which allows the NLRC to apply provisions of the Rules of Court by analogy or in a substitutory manner. So again, your situation in the bar is that your client doesn't have financial statements, or even if it does, the losses covered by those statements, okay, are matter of months only. Okay, months only. But if your target, this being the middle ground, is to prove retrenchment based on expected losses, those statements are not useless because they can be used to prove a trend of losses. So please be ready for hypothetical questions, calling for or testing your higher order thinking skills. So those who can answer questions of that kind are ready to practice labor law. So they will be allowed by the examiner to become lawyers. Second middle ground is the do each his loss rule. So, pandemic setting, the employee reports for work is not allowed entry. Why? Because he does not have a medical clearance. Another possible situation in the bar problem or in the bar is an employee is placed on no work, no pay status. He is not recalled, okay, after 6 months. So, in both situations, the employee runs to the office of the labor arbiter to file a complaint for illegal dismissal. It depends on the company. Okay? In both cases, is abandonment or would be abandonment. Okay? Based on the fact that the employees have joined the employee of another employer. Okay? In such case, you are going to apply the to each his loss rule. What is the basis of this rule? On the part of the employer, lack of intent to dismiss, and on the part of the employee, lack of intent to abandon. Take note that you have to remember the overt act test. Okay, the overt act test. Has the employer committed an overt act, okay, resulting in the complete severance of employer-employee relationship? If that element is present, then there is dismissal. In its absence, there is no dismissal to speak of. On the part of the employee, there is no abandonment unless he has unjustifiably refused to render work and he has committed an overt act from which his intent not to resume work can be deduced. So, in those two situations, example which can be given in the bar, quite possibly. You're going to apply the to each his loss rule. In other words, the employer shall bear the loss of his employees' services, and on the part of the employee, he must bear the loss of his wages. So this is a middle ground that can be safely used in a pandemic setting. So this is one is very, very simple. Okay, to each his loss rule. In the case of Chungguan Marketing vs. NLRC, the employee was told by a person that he had been dismissed without the benefit of verification, without having ascertained first from management if he was really dismissed. He ran to the office of the labor arbiter to file a complaint for illegal dismissal. In the employer's position paper, this defense was interposed. He had abandoned his work, but the Supreme Court would not agree that there was abandonment in that case for one of the two requisites or the twin requisites of abandonment. That is, the employee did not unjustifiably refuse to work, and that he did not commit an overt act from which his intent to resume work could be safely deduced. And on the part of the company, had the employee made a verification, he would have found out that the company did not really intend to dismiss him. So the Supreme Court said, you too should be restored to pre-litigation status. Each one of you should now bear your losses. Again, on the part of the employee, the loss of his wages, and on the part of the employer, the loss of the services of his employee. So this middle ground is quite easy. There might be a repeat of the bar problem calling for a remedy. So again, the bar problem given several years back was notices of retrenchment were served on several employees. What course of action would you take to protect the rights of those employees? So I gave you the three options that were not available. The regional director did not have the power, as he continues not to have it, to enjoin retrenchment, even if he found or he finds that the same has no basis. RTC would not issue a TRO to stop the intended retrenchment for lack of jurisdiction, and unless there is a principal case initiated by a complaint for illegal dismissal with the Office of the Labor Arbiter, the CA or the NLRC cannot exercise its injunctive power as held by the Supreme Court in Powell versus NLRC. So again, why did the bar examiner give that kind of problem if there was no remedy to use at all? He had wanted to surface a power given to the Secretary by Article 277, which is now Article 292, and that is the suspension of the power of the Secretary. The provision reads, the Secretary of the Department of Labor and Employment may suspend the effects of the termination pending resolution of the dispute. In the event of a prima facie or prima facie finding by the appropriate official of the Department of Labor and Employment before whom such dispute is pending, then the termination may cause a serious labor dispute or is in implementation of mass layoff. So what is your remedy? Applying this provision or invoking this provision? Okay. Ask the Secretary to exercise his suspension power, to suspend the effects of the intended retrenchment. How? You go to the regional director, if the case is still with him, or the labor arbiter, if the case has advanced to this stage or level, to ask that a report be submitted to the Secretary. Okay? Based on prima facie or prima facie finding that the intended retrenchment or the retrenchment, okay, is in implementation of a mass layoff or will cause a serious labor dispute. Okay, so based on that report, the Secretary may exercise his suspension power. This is not being used. It's not being used in real practice. Okay, but the bar examiner was aware of this power given to the Secretary. That's why he used it in that bar problem. So what is the middle ground here? Exercise by the Secretary of his suspension power. So we are talking of instant remedy. Filing of the case with the labor arbiter means that his decision can be elevated to the NLRC on appeal, then to the certiorari court, and then to the Rule 45 court. That will take many, many years. So if you're asked to give an instant remedy, okay, quite possibly this is your instant remedy, to ask the secretary to exercise his suspension power. I bring you back to the office of the labor arbiter. There is a case involving a retrenchment supported by the employer with financial statements, audited financial statements covering losses incurred from several years of operation. Your role is to protect the interests of the retrenched employees. Now you have a credibility issue to raise. However, the labor arbiter would not conduct a clarificatory hearing so that your questions could be propounded by him. So he tells you that he has 30 days to resolve the case and cannot entertain your questions. On top of that, he tells you that he has to submit his decisions on before the 10th day of the following month. So he decides the case based on the record of the case before him. Your remedy, of course, is to appeal his decision to the NLRC. But you have to see to it that you raise the credibility issue in your appeal, because according to the Supreme Court in United Placement International versus NLRC, the NLRC cannot resolve an unbrought issue. So an issue that is not raised on appeal cannot be resolved by the Supreme Court for lack of appellate jurisdiction. So the issue has to be raised. Now, what can you ask the NLRC to do? Remember that the NLRC has several powers under Article 225. It has the power to refer technical matters to an expert. It has the power to correct, amend, or waive any error committed below. So your first remedy is to ask the NLRC to refer the technical matters to an expert. You came from the labor arbiter, okay? And you failed to destroy the evidence of the company or the employer. You're now going to ask the NLRC to refer the matter to an expert so that that expert could conduct an honest-to-goodness financial statements analysis. Okay? Your other option is to ask the NLRC to remand the case to the labor arbiter for further proceedings so that you can present your additional evidence, or you would have the opportunity to destroy the evidence of the employer. When the case is remanded, okay, certain rules are waived, no? Like, for example, the labor arbiter is no longer required to resolve the case within 30 days. Tapos na yun okay? He's no longer required to submit his decision on or before the 10th day of the following month. Tapos na yun. So, in other words, okay, when the case is remanded, the labor arbiter and you will have more time to present more evidence, if not to destroy those financial statements. So before the labor arbiter on a remand, you can already destroy the employer's evidence. So this is another middle ground that can be utilized. We are expecting several hypothetical questions, okay, because of COVID-19. There are several areas of engagement, okay, occasioned by COVID-19. So this is one of them, okay. Take note of Article C. It does not allow the Commission to resolve any and all issues. Okay? Its review power is limited to issues brought up on appeal or raised on appeal. So the very reason it cannot resolve an unbrought issue is lack of appellate jurisdiction. So please remember this United Placement International versus NLRC case. Okay, we are done with the tellurial issues. Let's now go to the second, which is remunerative issues, or money issues. Issues generated by the employer's non-payment of earned wages or salaries and accrued benefits. Now, let's talk about burden of proof. The rule is it is the employer's burden to prove payment, okay, with clear positive evidence, but only after the claimant, the employee, has shown the basis of his money claim, that his money claim is due and demandable. And on top of that, must show the particulars. So the law requires the employee to particularize his money claims, okay, to enable the labor tribunals to make a proper determination of how much to award. So more or less that is a burden of proof involving money claims. Here's a special law on wages, the Double Indemnity Law, or RA 8188. This is not only a labor law, it is also a penal law, right? Because there is criminal liability under this law for employers who do not comply with wage orders, who withhold wages. Now take note of what the Supreme Court told us in Sapio versus Undata Construction. This is a wage law, okay? So it does not apply to money obligations that have nothing to do with wage or wages. The special features of this law are, number one, an employer who does not comply with the wage order can be ordered to pay double the amount of the wage he has withheld. Number two, he can be criminally prosecuted for his unlawful withholding. And the Supreme Court in Sapio told us that payment will not bar criminal prosecution. Payment will not bar criminal prosecution. Now, here is an NLRC NBank resolution, NBank resolution number 01-19, series of 2019, which permits an employer to pay the amount of the original claim, okay, sans application of the double indemnity law yet. So if he receives a judgment, a money judgment from the labor arbiter, okay, he is given 5 days to settle the money judgment. So if he does that, then this resolution will not require him to pay double the amount of the unlawfully withheld salary. But if he does not pay, instead he takes an appeal. If he loses his case under a final judgment, then during execution, this law can be applied already by doubling the amount of the unlawfully withheld wage. So this should prove convenient on the part of employers in a pandemic setting. If they do not want to be bothered by the double indemnity law, their option is to pay the money award within 5 days from receipt of the money judgment. Otherwise, the law would be applied later on during execution. Principle of unjust enrichment. This principle was applied by Justice Velasco in the case of Genuino, involving a payroll reinstatement. So he ordered the return of salaries paid to the employee pending the employer's appeal. That employee was given a reinstatement or a payroll reinstatement. And the justification given by Justice Velasco was that he would be enriched at the expense of his employer if he did not reimburse. But in the NBank case of Pal versus Garcia et al., the Supreme Court would not apply this principle. Okay, the case involves also payroll reinstatement. And the reason for that was to order reimbursement was to drive the employee to penury, or the employees to penury. Take note that an employee does not have the right to choose the kind of reinstatement he wants. Okay, the kind of reinstatement he gets is entirely the discretion of his employer. So since payroll reinstatement is entirely the decision of the employer should not be rewarded for his having chosen to give his employee a payroll reinstatement. What employee would ever agree, said the Supreme Court, to a payroll reinstatement if at the end of the day he would be required to reimburse? Take note that at that point he would have spent everything already. So the effect of an order requiring him to return the money is to drive him to penury or to poverty. In at least 2 cases, however, the Supreme Court applied the principle of unjust enrichment. The first case involves a clerk of court of Quezon City, RTC Quezon City, who was dismissed by the Supreme Court on the ground of immorality. The legal effect of the dismissal of a government official is the forfeiture of all his benefits, including retirement pay. Now, so that was the effect of the dismissal of that clerk of court, a lawyer, a member of or an officer of the court. At one point, his son went to the Supreme Court to pray that the Supreme Court direct the GSIS to return the personal contributions of his father, because when he initially asked the reimbursement of such contributions, the GSIS
resisted his claim. Supreme Court said you return the personal contributions of Attorney Liedo because they are his personal property. If you don't, then you would be enriched at his expense. The second case is Wallen of 2015, the decision of Justice Lionel, involving restitution per Section 18, Rule 11 of the NLRC Rules of Procedure. What happens if the labor arbiter refuses to issue a restitution order? Why? Because the decision of the Court of Appeals, okay, does not direct restitution. So it is on the basis that he does not want to issue a restitution order. Is his refusal proper? Strictly applying Section 18 of Rule 11, his refusal to issue that order has basis. But then this solemn ruling tells us that whether or not restitution is ordered by the CA, okay, does not matter. The seafarer should return the money paid him, otherwise he would be enriched at the expense of his employer. So common sense requires such a restitution. Okay, so even absent an order from the CA directing restitution. This has not been given in the bar yet. Now take note that Section 18, Rule 11 has not been amended yet to conform to Wallen. So the law to apply is Wallen. Don't be misled by the non-amendment of Section 18, Rule 11.
Dutch Movers of 2017 gives us sure protection for workers who have obtained a favorable judgment, but which judgment they cannot enforce because their company, the respondent in the case they have filed, has disappeared, okay, under pandemic circumstances. Now, so a judgment is rendered, say by the labor arbiter, in favor of several workers displaced by reason of the pandemic. Now, it's now time to enforce the judgment because after all, it has attained finality. The problem is the sheriff cannot find the respondent company A. So he makes a return. Okay, he tells the labor arbiter that he could not find company A. Instead, he found company B. And that company B has the same set of incorporators. It is using the same premises. It is using the same lease contract over said premises, etc., etc. So on that basis, the labor arbiter pierces the veil of the corporate fiction of company B. Can the labor arbiter do that? The answer is no. Okay. Kukan International of 2010 tells us that there is a need to implead company B first in the case before it can be made liable under the judgment. Why? Because piercing the veil of corporate fiction is not a means of acquiring jurisdiction, but a means of determining liability only. I repeat, okay? Piercing the veil of corporate fiction is not a means of acquiring jurisdiction, but a means of determining liability only. In other words, company B should have been impleaded from the very start because that is a requirement of due process. But there is an exception. Even if a B was not impleaded in the case, it can still be made answerable under the judgment if there is evidence that it is being used as an instrumentality to evade the judgment. So this is an exception to the Kukan International Corporation rule. And this is a source of protection now for the workers who cannot find their employer anymore. Okay. So please take note of Dutch Movers because it has not been given yet in labor law.
The NLRC has several powers. It has review power, injunctive power, it has compulsory arbitration power in assumed cases, and it has rulemaking power. Now, in the exercise of its rulemaking power, it came up with Section 18, Rule 11 on restitution. The provision reads, where the executive judgment, so judgment, money judgment has been enforced already, where the executive judgment is totally or partially reversed by the Court of Appeals or the Supreme Court with finality and restitution is so ordered, the labor arbiter shall, on motion, issue such order of restitution of the executive award except reinstatement wages paid pending appeal. Now, this is restitution, meaning the worker, the employee should return the money paid him. Go back to the case of Pal versus Garcia et al., where the Supreme Court would not order reimbursement, but this one involves payroll reinstatement. In the earlier case of Genuino, Justice Velasco ordered reinstatement of salaries paid under a payroll reinstatement after the employer has obtained a reversal decision or judgment. And his reason was that if the employee would not return the money paid him, then he would be unjustly enriched at the expense of his employer. That was overturned in Garcia by the Supreme Court. This one is an en banc decision wherein the Supreme Court would not apply the same principle of unjust enrichment, reasoning that to compel the employee to return money or salaries paid him under a payroll reinstatement would have the effect of driving him to penury. Okay? Remember that the reinstatement, the kind of reinstatement an employee gets is not the kind of reinstatement he wants, but what his employer is willing to give him. Now, what employee would ever agree to a payroll reinstatement if at the end of the day, when he shall have spent everything already, he would be compelled to reimburse? Okay, so the employer should not be rewarded for his having opted to give his employee payroll reinstatement when that employee would have wanted to get an actual reinstatement. So the principle of unjust enrichment was not applied by the Supreme Court. But in Walem, it applied the principle of unjust enrichment. Take note that the Court of Appeals did not order restitution. So the labor arbiter would not order restitution based on Section 18, Rule 11. But the Supreme Court said, okay, common sense requires that reimbursement restitution should be effected, that the seafarer should return the money paid him, the compensation award given him. Otherwise, he would be enriched at the expense of his employer. So, don't be misled by the fact that despite this ruling of the Supreme Court, Section 18, Rule 11 of the 2011 Rules of Procedure of the NLRC has remained as is. In other words, the Commission has yet to amend its rule to conform to jurisprudence. So you might be given a bar problem involving this provision of the Rules of Procedure of the NLRC. Do not be misled by the non-amendment. Okay, you apply Wallet. I'm very sure the bar examiner will kill a seafarer with COVID-19 or kill a GSIS member with COVID-19. So your task is to tell him whether or not to allow the death claim. Now start with the seafarer killed by the bar examiner with COVID-19. Should you or should you not allow the death compensation claim? For death to be compensable, okay, where the death is caused by disease, the disease must be work-connected, and number two, it must have been contracted during the period of the seafarer's employment contract. So these are the requisites for compensability. Now, work connection means that the disease resulting in death must be a listed disease. In other words, it can be found under Section 32-A of the POEA Standard Employment Contract for Seafarers. Take note that you cannot find COVID-19 under the list or on the list simply because at the time of the preparation of the list, COVID-19 was unknown yet. So you have a problem, okay? But Section 20 of the POEA SEC provides that all unlisted diseases shall be disputably presumed to be work-connected. Okay. But you have another problem because of the conflicting rulings of the Supreme Court on the matter. Before 2014, before it gave us its Racelis ruling, the Supreme Court still required claimants to prove work connection despite the disputable presumption of work connection. In 2014, in the case of Racelis, okay, it changed its mind. The Supreme Court changed its mind. It already laid the burden on the employer to overcome the disputable presumption. So the reason, or one of the reasons it allowed the death claim in Racelis was the employer failed to overcome the disputable presumption that the unlisted disease that killed the seafarer was work-connected. The disease was brain stem cavernous malformation.
It could not be found under Section 32A of the POEASEC. For that reason, it was not work-connected, but it was covered by that disputable presumption, which the employer failed to overcome. So, among others, that was the reason why the Supreme Court allowed the desk claim. Now, after 2014, in 2015, in the case of Likayan, the Supreme Court returned to its pre-Racelis ruling that required claimants to still prove work connection even if there was that disputable presumption that unlisted diseases were disputably presumed as work connected. So we have conflicting rulings on work connection or on the disputable presumption of work connection. Luckily, in 2017, Justice Bernabe gave us Benedict Romana versus Magsaysay Maritime. Okay? And this case is so important because it has given us the harmonization of the reconciliation, okay, between these conflicting rulings of the Supreme Court. Here is now the reconciliation. Supreme Court in this case told us that the disputable presumption of work connection applies only to the first requisite. So again, the requisites for compensability are work connection and effectivity of contract. Okay, so the disputable presumption applies only to the first requisite, but not to the second requisite. For that reason, entitlement to compensation or compensability should be proven with proof of requisite number 2. That's why the burden is still on the claimant to prove compensability, not work connection, but compensability by proving requisite number 2. So how does he comply with that requisite? Okay, Romana says by proving 1, 2, 3, 4. 1, 2, 3, 4. Okay. In other words, the claimant must prove the risk factors of the unlisted disease. Every disease, listed or not, has a risk factor or risk factors. Like lung cancer, the risk factor for that is exposure to chemicals. So AML, which is a form of cancer, has for its risk factor exposure to benzene. So every disease has a risk factor or risk factor. So number 1 means that the claimant must prove the risk factors of the unlisted disease. Number 2, he must prove that the work of the deceased seafarer involves those risks. So, if the disease is cancer, okay, the risk factor of which is exposure to chemicals, which is the case when a seafarer is assigned to an engine room, but the seafarer is assigned elsewhere, then requisite number 2 is impossible of compliance. Number 3 requisite, the claimant must prove that the period of exposure of the seafarer to those risk factors was sufficient for him to contract the unlisted disease. And number 4, the claimant must prove that the seafarer was not guilty of notorious negligence. So proof of 1, 2, 3, 4 is proof of compensability. Why? Because after having proven 1, 2, 3, 4, the claimant would have proven requisite number 2. So please remember this one. Again, the disputable presumption of work connection applies only to the first requisite, but not to the second. So, proof of compensability requires proof of requisite number 2, and the way how is to prove 1, 2, 3, 4. Now, this has a parallel under the Employees Compensation Act, which is now the amended rules on employee compensation. So what if the bar examiner will kill a GSIS member with an unlisted disease? Okay? Take note that for deaths caused by disease to be compensable, the disease must be occupational, which means that it is also a listed disease. But the list to consult is not Section 32A, but Annex A of the Employees Compensation Act or Annex 1 of the amended rules on employee compensation. So if the disease resulting in death is not listed, then the disease is not occupational, therefore the resulting death is not compensable. Now, as I said, the bar examiner will kill a GSIS member with COVID-19, which is an unlisted disease. Is there a disputable presumption that COVID-19 is occupational? Answer, no. There is no equivalent disputable presumption under the amended rules on employee compensation.
So for that reason, the law requires that the claimant prove the occupational character of the unlisted disease. So with substantial evidence, the claimant must prove the connection, okay, between the death and the work performed by the member, okay, through the instrumentality of one of these theories, no? The proximate cause theory and the increased risk theory. In other words, the claimant is allowed to prove the occupational character of an unlisted disease with the use of these two theories. How does the first work? How does the proximate cause theory work? The claimant must, with substantial evidence, prove a chain of causes, okay, connecting performance by the member of his work and his death, and prove that that chain of causes is unbroken by any efficient intervening cause like notorious negligence, intoxication, intentional attempt against the member's life or against the life of another. So if the chain of causes is unbroken by any of those efficient intervening causes, then the compensation claim should be allowed under the proximate cause theory. In the case of Bellarmino, a school teacher, public school teacher, was killed by an unlisted disease, namely postpartum septicemia. Now, the GSIS denied the death claim, but the Supreme Court reversed the GSIS. Okay? It allowed the death claim. Why? Because of the proximate cause theory. Because the Supreme Court saw a chain of causes connecting performance by the teacher of her work as a teacher and her death. Okay? So what we found in the chain of causes? She was a public school teacher, okay, who was a dedicated teacher who went to class every day, despite the fact that she suffered an accident. Okay, she figured in an accident inside her classroom. Okay, prompting her co-teachers to advise her to take medical leave, but which she ignored because of her dedication. So she continued to go to class to teach until it was time for her to deliver her baby, because she happened to be pregnant at the time. Because she was a poor school teacher who could not afford the services of a private hospital, she had to deliver at home where conditions were not sanitary or clean. Okay, reason she contracted postpartum septicemia. So what did the Supreme Court see? It saw a chain of causes connecting the teacher's performance of her job and her death. It did not see any efficient intervening cause. So on that basis, it had to allow the death claim, reversing the GSIS. The other theory is the increased risk theory. Now, how does this theory work? The claimant should, or the question to ask and answer is this: has performance by the member of his work increased his risk of contracting the unlisted disease? If the answer is yes, then you allow the death claim. This is best illustrated by the case of Dr. Garupa, who was a government physician and who was killed by an unlisted disease, namely glomerulonephritis. So if you go to section or to Annex 1 of the amended rules on employee compensation, which was formerly Annex A of the Employees Compensation Act, you would not find glomerulonephritis. In other words, it is an unlisted disease. So on that basis, the GSIS denied the death claim, but then the Supreme Court allowed the claim. Why? Because of the increased risk theory. Again, the question to ask is, has performance by the member of his work increased his risk of contracting the unlisted disease? If yes, you allow the claim. In the case of Dr. Garupa, the GSIS member was a government physician who worked as such for 20 years. And in those 20 long years of service, she got exposed to all kinds of bacteria, including Streptococcus bacterium, which was the cause of streptococcal infection, which in turn was the cause of glomerulonephritis, which killed her. So what did the Supreme Court see? Okay, the performance by the member of her work increased her risk of contracting glomerulonephritis and unlisted disease. So applying the increased risk theory, the Supreme Court allowed the death claim. So the law on seafarers and the compensation claims of GSIS members have parallelisms. Okay? The difference is for GSIS, there is no disputable presumption of work connection. For that reason, the claimant is required to prove the occupational character of the unlisted disease, okay, with substantial evidence, okay, by with the use of the proximate cause theory or the increased risk theory. Okay. Now, what happens if the claimant cannot prove the occupational character of the disease? No? Simply because even medical science cannot explain the origin of the disease. In the case of Abraham Kate, the claimant was disabled by an unlisted disease, or osteoblastic sarcoma. Back then, that disease had no explanation as to origin. So it became impossible on the part of the claimant to prove the occupational character of that unlisted disease. The Supreme Court said where even medical science cannot explain the origin of a disease, then the condition that the claimant should prove the occupational character of the disease is deemed not imposed. Under the circumstances, it becomes a void condition. It becomes a void condition. So in the case of Abraham Kate, the Supreme Court allowed the GSIS members a disability claim or money claim. Middle ground number 3, the equipoise rule. Equipoise rule. Again, let us allow the examiner to kill a seafarer with COVID-19, sending the widow to the labor arbiter to assert a money claim for death compensation. Defense of the employer, notorious negligence. Source, Romana versus Magsaysay. Now take note that Romana imposes on the claimant the burden of proving that the seafarer was not guilty of notorious negligence. Looks like it should be the other way around. No? It should be the burden of the employer to prove the seafarer's notorious negligence. But jurisprudence really requires the claimant to show that the seafarer was not notoriously negligent. So, the problem of the claimant is that he was not on board. He was not present aboard the vessel and therefore was not witness to the events taking place aboard that vessel and would not know about the alleged notorious negligence of the seafarer, consisting of his refusal to wear a face mask, to wear a face shield all the time. So, ganun ang defense ni employer. The seafarer was notoriously negligent by refusing his express instruction to wear a face mask, to wear a face shield all the time. However, even the ship captain failed to make an entry about that matter in the vessel logbook. Now, take note that any evidence not sourced from the vessel logbook would not be treated, would not be considered as substantial evidence. So, what is the situation of the parties? Both of them do not have evidence. Both of them do not have substantial evidence. In that case, we apply the equipoise rule. We appeal the scales of justice in favor of the worker. So, a middle ground. Okay. Suppose now here are the cases that we mentioned a while ago. So, Villasis is 2014. Okay. Villasis tells us that the employer has to overcome the disputable presumption of work connection. But in 2015, the Supreme Court gave us likayan that brought us back to pre-Villasis rulings that still impose the burden of proving work connection on the claimant or claimants despite the disputable presumption of work connection. The reconciliation was brought by Romana in 2017 when it gave us 1, 2, 3, 4 rule. Take note that 1, 2, 3, 4 rule is just a memory tool. Do not give that to the bar examiner. And take note also that I have simply simplified the 1, 2, 3, 4 requirement of Romana versus Magsaysay. Where the evidence is on the balance, you apply the same rule, equipoise rule. So you tilt the scales of justice in favor of the working man. So this is the third middle ground that we can use. I am done with my lecture. This has been a lecture under pandemic circumstances. Since up to now I haven't found the noise cancellation feature of my OBS, I could not prevent outside the sounds from coming in, so you could hear the sound of the cat,
the sound of the dogs, the sound of the ambulance and motor vehicles. Truth of the matter is that Dean Villasis invited me to his office to do my recording, but I told him that I wasn't certain that I was not a carrier of the virus. So since I didn't want his personnel to be infected accidentally, then I opted to do my recording at home. So I hope you were able to bear with the background noise. At any rate, I believe that I have given you the matters that you need to bring with you when you enter the gates of UST to challenge the bar exams next year, probably in March, if not in November. No, I'm not sure. No, nothing is really certain at this point. So thank you for your participation, for your kindness of listening to me, of listening to my lecture on tenurial and remunerative issues in a pandemic setting. So again, our objective has been to look for pre-existing middle grounds, okay, to use so that the rights of employers and employees would get the protection that they need. So thank you very much to the VLC again for inviting me, for making me a part of its lecture series.
Good day, VLC Warriors! Please visit and subscribe to Villasis Law Center YouTube channel. Together, we can make things happen. Together, we can.
Of course, in cases filed against you, you don't merely avoid conviction. Of course, there are some things that you would also have to consider. First, the time. Second is the investment. Third is the opportunity. Fourth is your peace of mind. And fifth is your personal wealth. So out of the 100 targeted accounts, hackers were able to reset 45 user accounts' passwords. Now, these hackers
be very fast in saying, yes, I want to go fishing with you, because this person might be talking about a different kind of fishing, a fishing that will lead to a criminal offense and probably put you in prison.
Does not fall under the Data Privacy Act if it is an information pertaining to an entity that is not a natural person. consent must be something that is mechanical and tangible. It must be proven. That is consent that is required under the Data Privacy Act. You have to prove that you have obtained the consent from a data subject. So who may wish to have some questions, probably they can send their questions to the Villasis Law Center and we'll try to answer them.
Three things, no? We were reminded by the National Privacy Commission that the cardinal rule, if you talk about processing of data information, is that do not collect if you cannot protect. The primary impact of the Data Privacy Act, my friends, are the 8 rights provided by law. Very important. There are 8 rights here. You talk about the right to be informed, the right to access, the right to erasure or blocking, the right to object, the right to rectify. You talk about data portability, the right to file a complaint, and of course, the right to damages. Data is more valuable than money, because if someone takes your money, that's all they have, okay? But if you let someone take your data, oh my God, eventually they will take your money too.
So does the DPA only cover personal information per se? Or does it also cover information about companies, testing results, and...
Hi, sir. Good
Hi.
evening. Sir, just a question about the DPO officer. Is there such a thing as a void or not valid DPO officer appointment, wherein even though the NPC has properly recognized his appointment?
We will be having our second quiz.
Just kindly, enter the link in the chat box, okay? So we can get started. So I think a little bit of an icebreaker is in order. Can we bring out the wheel?
Yes, we will do again a raffle. Congratulations! Ronaldin A. Urbon.